Trademark infringement or unauthorized use can be a costly mistake under particular circumstances. Trademark owners may bring legal action against using, copying, or impairing their trademark or service mark in federal court. In this video, I want to talk a little bit about the Lanham Act and explain how to avoid such trademark infringement cases. Let's start with talking about what is trademark infringement. According to U.S. trademark law, there are three main ways to achieve trademark protection. We know all about common law trademarks, usually harder to enforce due to geographical limitations. State trademark registrations, they exist, but they also have geographical limitations, but they provide trademark protection for their related goods and services in the registered state. Federal trademark. Registration at the United States Patent and Trademark Office is the gold standard for any brand or trademark owner. Any and everybody who wants to do business in the US, and most brand owners do, need to have a registered trademark at the uspto. Trademark infringement for registered trademarks occurs when someone uses a substantially similar or the same branding as the plaintiff's mark without permission or licensing. The plaintiff must believe that the use will cause consumers to confuse the origin of its goods or services. Trademark protection through a federal registration at the uspto allows trademark owners to pursue trademark infringement proceedings. The defendant's intent only comes into play if the trademark infringement was willful. For example, in a case from 2020, New Balance argued that New Bundaran, a Chinese shoe company, was deliberate in its violation. New Balance showed that New Bundaran continues in infringing activity after being notified. New Bundaran used virtually identical marks on virtually identical goods to deliberately deceive customers. The district court found in favor of New Balance, ordering New Bundaran to pay statutory damages. To prove infringement, a federally registered trademark owner must show that the plaintiff's mark is legally protectable and valid. The plaintiff owns the mark, and that the defendant's use of allegedly infringing mark with the competing or related goods or services causes a likelihood of confusion. Evidence of actual confusion is not required for consumer confusion, although confusion cannot be hypothetical. To establish a likelihood of confusion exists, there must be confusion on the consumer's side regarding the source of good or service. The infringing mark must be substantially similar to the mark of the plaintiff's for the related goods or services. Let's talk about the common types of trademark infringement claims. Trademark infringement can come in many forms. It can be in the form of counterfeit goods which mislead the public and confuse the product source. Like I mentioned, the New Balance and New Bundaran case is one of many trademark infringement examples that involve willful infringement of a logo by selling counterfeit products. Brands should work with the trademark attorney that can apply anti-counterfeiting strategy to minimize trademark infringement. A common trademark claim is also trademark dilution. There are usually two types of dilution: dilution by blurring and dilution by tarnishment. The claim usually involves a plaintiff's famous mark, where the defendants use a mark which is similar or the same in commerce after the famous mark reaches to meet the threshold of trademark dilution. Basically means that the existence of this defendant's mark is going to weaken the plaintiff's mark. Trade dress infringement occurs when the plaintiff's mark is registered to protect a product or service's overall image and appearance. This usually includes color marks, sound marks, motion marks, and other non-traditional marks. For example, Tiffany & Company protects the Tiffany blue as a part of its unique look. Additionally, it is a quintessential part of the brand's appearance, as seen in packaging, ads, social media presence, licensing deals with Nike, and so much more. Sometimes a brand owner has developed a brand name or identity that they want to represent on the internet. Unfortunately, it is widespread for a trademark owner's mark to not be available as a domain name due to cyber squatting. In this scenario, working with a trademark attorney to determine your options is best. The options usually include a cease and desist letter, a federal lawsuit involving ACPA action, or a UDRP and URS administrative proceeding. Although trademark protection begins since the day you start using it through common law rights, trademark protection really begins with the registered trademark of the United States Patent and Trademark Office. Without registration, a brand owner is limited to bringing a lawsuit on the false designation of origin charges. Common law trademark rights are limited, and to provide comprehensive protection for your brand, a brand owner must develop a diverse trademark portfolio. Trademark protection is nothing without enforcement. Enforcement of a brand should include monitoring and policing services, but it should also have decisive action when two marks are similar. Cease and desist letters, TTAB proceedings for opposition or cancellation, or federal trademark infringement lawsuits should be considered when enforcing a trademark. When a trademark owner fails to enforce their trademark rights, it weakens their ability to implement it in the future, a very use it or lose it approach. Although TTAB proceedings can bring resolution, they will not yield any monetary relief for damages or legal fees sustained by the plaintiff. Court orders for an injunction or damages, including attorney fees, are available and actionable in federal court. Bringing a lawsuit should be the last resort, and not every infringement requires expensive federal court filings. A thorough review of ownership issues, market risks, and realistic solutions should be at the heart of a trademark owner's enforcement policy. This is where a trademark attorney can be of assistance. You must understand the risks of not acting against infringers as a brand owner. Hiring a trademark lawyer for brand development, enforcement, and prosecution is essential. If you need assistance with a trademark infringement claim or other trademark issues, please book a consultation with a firm by calling 773-234-1139 or www.drishilaw.com. As always, this is Sahil Malhotra. Thank you for watching.